Thank you so much for watching Voices of the Bar, where the legal world speaks. I want to discuss two very important topics in criminal law: how to answer uh, inchoate or incomplete offenses, and how to answer parties to crime. I'm going to single out what the lecturer expects out of you when you are answering those two topics. Number one, when we are answering inchoate offenses, the first thing is for us to appreciate what do they mean. You must mention what we mean by incomplete offenses. You must give those elements of incomplete offenses, because this is the gist of the question. They are saying inchoate offenses, that these offenses are incomplete, but again somebody is charged for them. Okay, incomplete, but in one way or the other they are complete, simply because someone has been charged because of them. So that one is very important. Then you must know the three types, which is incitement, attempt, and conspiracy. Now, when you're discussing incitement, first you must know the meaning of incitement, that someone instigates another to commit a crime. But again, there is a definition which has been given under section 21 of the penal code. So you must also give the general meaning of incitement. You must give the meaning as per the act. Okay? Then you must explain how can someone be incited. Of course, we all know somebody can be incited through words. They may be words or written. You must write about all this. And very important, if you have a case on words where someone was incited by words, kindly give the case. And then give a case if you have a case where someone was incited by writings. Okay? Then remember, all that we are just introducing, we are still on introduction. Then we go and talk about incitement. After defining incitement, you have talked to now someone who can be incited. You now tell us what is incitement. You now explain how does incitement occur. In other words, you are saying that there is someone called the inciter who incites the incitee. And when we see the incitee working from what they were told, then it means that the incitement has reached the mind of the incitee. Therefore, we have a crime there. Okay? You must indicate to the examiner that the inciter incites the incitee, and when the incitement reaches the mind of the incitee, then we see the incitee starting to work, basing on the incitement which was taken to him. Okay? You must bring out clear. Then from this point you bring the different cases. R. Edwards, the race board case, and very many other cases. Ensure that the moment you leave incitement, you have given at least the minimum is 4 cases. Just incitement. 3 is the minimum, maximum 4 cases on incitement alone. Okay? So if you don't have the cases, ensure that you get those cases. Then we go to conspiracy. Conspiracy. Now, under conspiracy, give us the meaning of conspiracy as per the section of the penal code. Should be 363. As per the section of the penal code. Okay? Now, after you have given the insight as per the section of the penal code, Then, or about conspiracy, two or more people coming together to commit a crime. Yes. Now, all the Ugandan cases of conspiracy, they have defined what conspiracy is. Look for that one case or under the Uganda cases that define the conspiracy. Then you can also define the conspiracy as per the case. Okay? What was said. Of course, they are the same definitions. So just get a case and say, in the case of so and so, the Lord Justice or Justice so and so define the conspiracy to mean where two or more people come together with an agreement to commit a crime. Okay? Now, and after explaining all that, you now tell the examiner, how does a conspiracy, I don't know, how can someone join a conspiracy? Someone joins a conspiracy at the start when you participate in the meeting. So if you don't go to police to report, you are part of the conspiracy. Then others during, when the people who agreed are now executing. Now during, if you find them when they are robbing a bank, when they are doing something, and you don't report them to police, you inquire or don't even inquire, you join, you help them, you have joined a conspiracy. Then you also explain that a conspiracy can be joined at the end, that after these people have committed their crime, now, after they have committed their crime, they now do what? You find them, you join them, you don't go to the police, you have joined a conspiracy. Then you discuss about accessory after the fact, especially for a wife under conspiracy. Okay? Remember, a wife is not held liable for anything under accessory of the fact for hiding the husband. Okay? So what is the position when the wife hides other people other than the husband? What happens in that scenario? So you now give cases where conspiracy was held or done. So the minimum case we have agreed under conspiracy, there are 3 cases, maximum 4. Okay? Then there you are good to go. Then we go to the very last one, which is attempt. Now, attempt, use section 359 to define what is attempt. What has the act said about attempt? The act is saying that when somebody puts their mind together, okay, and they start preparation, doing necessary steps towards the commission of the crime, and this is done by showing some overt act. Okay, some overt act. So you explain that after. Now, there is a word which has been introduced, overt act, but we know section 31 of the penal code has started to be guided. Section 31 of the penal code, we know that it has defined what an overt act is. You can go ahead and explain what is an overt act under that section 1 of the 31 of the penal code. Then from there, you now give cases. Explain that when somebody puts their mind together, and they begin to take necessary steps in furtherance of committing a crime with some overt act, you now bring all the cases. In the case of R versus White, okay, you bring very many cases, okay. Then from there, you don't stop there. There is some exceptions under section 339, I think 2, where they say that it is immaterial whether your actions are the one that led to the cause of the death or not, for as long as you manifest in your aspiration in an overt act, you manifest them, then you are the one. So you bring those sections which say it is immaterial whether was your action or somebody died of a natural death. It is immaterial for as long as you manifest your manifestation, your aspirations by some overt act in the furtherance of committing a crime, you are held liable. You should explain section 359 very well, and you complete it. So 3 cases is the minimum. So by this time now, we have 10 cases on just one number. incomplete offenses, or what we call the preliminary offenses, or what we call the inchoate offenses. So now, let us now cross to participation, parties to a crime. Now, when a question needs you to discuss the parties to a crime, the first thing we must do, one, is to define what is parties to crime. It has a definition, okay? Defined it, that is, when it comes to determine, everybody has a certain degree of participation. So everybody is charged according to their participation, their different liabilities when a crime is being committed. Then from there, you must appreciate, first, before you even go anywhere, inchoate offenses. Those are the only offenses you have covered this semester. There are no any other offenses you have covered this semester. I repeat, the inchoate offenses are the only offenses you have covered this semester. Even when you see murder, you see rape, you see defilement in the problem question in first year, please, you have not seen them. You only have 3 offenses: attempt, incitement, and conspiracy. Okay, now we can cross to parties to crime. Now, you must know these 2 topics why I'm doing them. You must have understood them, not just cramming. You must have understood these topics. Let's begin to break them down. Principal offender. Who is the principal offender? You must know, such that when you read the question, you are able to say this one is a principal offender. So we are saying a principal offender is someone who actually commits the crime. Okay? In other instances, a principal offender can be that guy who masterminds the whole plan. He may not go to the scene of crime, but he masterminds. He knows what everybody is going to do. He knows where they are getting the material. He has assembled all these people. Those people also sometimes, they are called principal offenders. They don't usually reach, some of them. But a principal offender, as per the act, is someone who actually commits the crime, who commits the actual crime. So you give cases there, but you must know who a principal offender is. Then let's go to procurer and counselor. I will handle them concurrent. Procurer and counselor. These 2, their role is simple. They encourage the crime to start. They encourage the crime to start. Okay? Now, what do I mean when I say they encourage the crime to start? But listen, if you go to the distinction between procurer and a counselor is that a procurer goes ahead and procures a few things that these people may need or will use when they are going to commit the crime. And then the counselor counsels, gives advice to these people on how to maneuver, on how to start. So that is the distinction. But what separates them from others is that a counselor and a procurer does not reach the scene of crime. Does not reach the scene of crime. They are not there. So you single out those people who are not there. Okay? Then we have abettor and aider. These 2, the difference is they reach the scene of crime. They are at the scene of crime. They are there. But their definition is they both encourage the crime to continue. To continue. An abettor is that someone who they said, for example, you go and stand there and nobody should find us, is abetting. Okay? Then that person, they tell, you be stand by, go this side, see, no one should find us, is abetting. There is that other fool who is guarding a bank. Okay? This is Centenary Bank and Equity. He sees people stealing Equity, and the fool says they are scary, that me, I'm paid to keep Centenary. If they are stealing Equity, let them steal Equity. That fool is also abetting. Then the aider is someone who actually helps, who is there. The principal offender tells you, send me this, is even guiding, advising, break like this, do this, is there helping the principal offender. That person is aiding the offense. Then finally we have accessory after the fact. Now, accessory after the fact, if the wife is protecting the husband for committing a crime, there's a full section. Discuss the section first. If the wife is protecting the husband, the wife will not be held liable. That's the first thing. The wife will not be held liable. Then two, all people they find after they have committed their crime, if they tell them what they are from doing, it will be a taxi driver, a borderman, or a passerby, if they tell them what they are from doing, and that person does not go to the police to report, that person has become an accessory after the fact. But if they stop a taxi and they enter, and they never tell that person what they are from doing, that person is not accessory after the fact. Then finally, joint offenders. We tend to skip joint offenders. These are people who have common intention and common purpose. They come together to commit a crime, but with common intention and common purpose. So look at those questions of parties to a crime. Look at them carefully and determine, okay? They might be saying that they planned, they agreed, they did this, those people are joint offenders. You see, they have a common intention and a common purpose. Be able, so when you're writing a question of parties to crime, you note down all of them: principal offender, aider, procurer, abettor, joint offender, accessory. Begin knocking down each as you find out. So we thank you so much for watching Voices of the Bar, where the legal world speaks. Subscribe, share, like our videos. Until next time, cheers.